Hello, I'm Susan Lipp, Editor-in-Chief of Trust and Estates. Welcome to Industry Insights. Our guest today is Doug Moore, Managing Director of U.S. Trust Family Office. And Doug is going to be discussing 3 issues that attorneys should be reviewing with their clients in light of the American Taxpayer Relief Act. So let's start with the exclusion amount.
Great. Thank you, Susan. Before I begin, though, I just want to mention that the statements I'm going to be making today are my opinions and not necessarily those of U.S. Trust or Bank of America. So what I want to talk about is that with the Taxpayer Act that just was enacted recently is that there are 3 important issues that really will require attorneys and their clients and other advisors to consider with regard to 3 important issues. The first is the certitude and more increased exclusion amount for federal, estate, gift, and generation skipping transfer taxes, which now is $5,250,000 per person, $10,500,000 per couple. The second issue that's of importance is portability. Again, it's now permanent. Congress has enacted that as going forward. So this way what will happen is those married couples will have, with their surviving spouse and the last deceased spouse, the ability to use the unused estate and gift tax exclusion amounts of the first spouse to pass away, not the generation skipping transfer tax exemption. That is not part of the portability provisions. And the third issue that I wanted to talk about is the potential disparity between the federal estate and gift tax exclusions and the state estate tax exclusions in many states.
All right, so do you want to begin talking about the exclusion amount?
Yes, as I mentioned, the exclusion amounts have gone up. They're quite significant. What a lot of clients and their attorneys did was they had formula clauses in their testamentary documents where they probably anticipated the amount for the exclusion amount to be somewhat less than the $5,250,000. And because the number is that high and will probably increase due to inflation, some documents may not have taken into account that high amount, and so that the dispositive provisions in the documents may not really be in keeping with what the individuals presently want or what they anticipate they'll need, and especially in fact of some spouses may have longevity, additional medical expenses, so there may be provisions that are skewed against or not in favor of surviving spouses, so the dispositive provisions should be taken into account as to whether or not these particular provisions in their documents really are current.
And then I think you also mentioned now that portability has become permanent.
Yes. Now portability, typically what had happened before, there was usually a knee-jerk reaction for a lot of advisors and their clients to try to have assets titled in the names of both spouses, so that way each spouse would be able to fully utilize their exclusion amounts. What's happened is a lot of people wanted to make sure they could fully utilize the credit shelter bypass trust in the first estate. The reason for that was to be able to avoid having the income and appreciation subject to estate tax in both estates. Now what's happened is with portability, for the federal estate and gift tax exclusion amounts being available for the surviving spouse, additional opportunities may occur where you may not feel compelled, for instance, to retitle assets. It may make more sense in some instances to have the surviving spouse die with more of the assets to get a step up in basis, because there may be a lot of spouses that with the combined federal estate and gift tax exclusion amounts of now being $10,500,000, that may be less of a concern than potential capital gains tax. Again, generation skipping transfer tax is not provided for in the portability, so that is a consideration.
And then finally, clients have to deal with now the disparity between the federal and state exemption.
Yes, and this is an interesting issue because there's approximately 20 states that have different exclusion amounts than the federal exclusion amount for estate and gift tax purposes. And for instance, in New York, the exclusion amount for state estate tax purposes is only $1 million. So if you have a bypass credit shelter trust, you can conceivably have a difference between the $5,250,000 and the $1 million for New York State, which could potentially accelerate the New York State estate tax by about $400,000 if you fully fund the credit shelter trust with the federal exclusion amount. So all these things have to be taken into consideration. And so taking that into account with portability, sometimes it might make sense for a surviving spouse to utilize the gift tax exclusion that may be available that was unused by the last decedent spouse to be able to avoid state estate tax, because most states, I think Connecticut is the only state that I'm aware of that still has a gift tax, so you can take advantage of gifting and avoiding state estate tax in those states that have a lower exemption amount.
Mm-hmm. All right. Well, thank you so much, Doug. And if you go to wealthmanagement.com, you could read more of Doug's insights.